Okay, this is a set of New York State law books, and I built this small bookcase to house these 5 books because each of these books has one of my case laws in it that did make the law books. It's very rare that your cases make the law books, but when you do so many, and I've done a lot, okay, every now and then one hits the law books. And it's published that way. And they are cited, okay, for people to review. And it goes by the book number and the page. So the first one there is book 697 of the New York Supplement second series, page 68, and so on and so forth. Hello, I'm the artist Michael R. Zotos, and today is June 27th, 2023. I'm making this little talk just to show a little bit of a diversification of myself. It has nothing really to do with artwork, technically speaking, but it does have something to do with I suppose, the way my mind thinks. And you know, I always did gravitate towards Wassily Kandinsky as an artist for 2 reasons. The first was that he is known as the first artist to come up with non-object artwork, and that's a big deal because today so much artwork as non-object. In other words, he started putting in paintings circles and squares and rectangles, and he made it stick. In other words, he did real art presentations, and the artwork took. The other reason is he was a scholar of law, okay? And I myself have dabbled in law quite a bit for myself. In other words, he was actually a professor of law. I did real estate transactions for quite a while. I happen to live on Suffolk County, Long Island, New York, where it's a suburban area. There are a lot of subdivisions that go back a long way. There are out parcels of land that were not built on. They're vacant. You could buy them, get building permits, and then sell them. And sometimes you don't get your permit. You have to go to court on it. And there are other reasons you would go to court. But it's not like you're going around suing people. Okay, you buy the property. You have to clear the title, and sometimes the title insurance company is not good enough to do it. You have to bring a court case, whatever the case may be. Okay, I wound up getting involved with the courts and learning it and making it work. Now, what I want to go over is the fact that some of my cases did go up on appeal. Okay, and when that happens at the Supreme Court level, it goes to the appellate division for the department in which your court is located. There are 4 departments, judicial departments in the state of New York, and I'm in the 2nd department. Well, anything that makes the appellate division also makes the law books. So I have 6 cases really in the law books, and I'm going to talk about a few of them right now. Okay, so I'm going to go over one of these case laws with you and show it to you. This is State of New York Mortgage Agency versus Hines, Michael R. Zotos, non-party appellant. Okay. And this is June 3rd of 2002. Now, in this instance, what happened here is that I entered into a mortgage foreclosure sale that was already in existence. I went to the sale to bid on the property. And when I got there were no bidders, just the referee. And he read the little speech, and then he said, the plaintiff bids $5,000. So I said, I bid $5,500. And he said, plaintiff bids $6,000. And I said, $6,500. And we went up a little ways. And then I said, wait a minute, you're the referee, you can't bid, you're the court. And he said, yeah, I know, but the plaintiff gave me bidding instructions and I'm bidding. So we went a little bit higher, and then not too high, under $10,000. And then I just stopped, and I decided, you know what I'm going to do is I'm going to make a motion in the case. I established that I did, in fact, bid. And then what I did was I made a motion in the case for to be declared the high bidder. And a motion is a request for a court order, and an action is a case, okay, a legal case. Well, I made a motion for an order, and the judge very quickly said, ha ha ha, lucky for you, goodbye, and he dismissed it, okay. And So I appealed, and I appealed very quickly to the appellate division. And what happened was, I know how to do that work, so I did it. And it takes a little while for all the papers to hit the court and for them to get in there and rule. But one big benefit to this was it was my first actual oral argument before the appellate division. And that's a big plus, because when you're going around doing real estate closings and contract signings in people's law offices, and you've had oral argument before the appellate division, you have a different kind of confidence after that. And there are things you know, things you could say that the other side's attorney can't intimidate you. And that's a plus. Well, anyway, the case law, what the appellate division said, and I'll just read some of this here. It said, in an action to foreclose a mortgage, blah, 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 Michael R. Zotos appeals from the order of Supreme Court, Suffolk County, Burleigh J., dated January 8, 2002, ordered that the order is affirmed with costs. Now, costs does not mean all their legal fees. It means like $250. The appellant failed to establish the existence of fraud, collusion, mistake, or misconduct as to warrant vacatur of the foreclosure sale and transfer of the premises to him. And then they cite a load of cases. All right. So I did not prevail. Now, why didn't I prevail? There were two reasons. One is that the plaintiff, the referee, was bidding on behalf of the plaintiff, who had laid out the money for the man to originally buy the property. And they had laid out $75,000. And now here I am trying to get it for under 10 grand. But the plaintiff, it had been Chase Manhattan Bank, I might have had a prayer. But the fact is, it was State of New York Mortgage Agency, an arm of the state. They lent the money, and so the court's not going to help me out. They don't care, okay? And obviously, this case law doesn't spell out that the referee was bidding or anything. It just said I didn't establish fraud or collusion, okay? The other thing is, I didn't go high enough, okay? I really thoroughly read the case law thereafter, and what I found is, had I gone, even if it was Chase Manhattan, I would have had to go at least $50,000 or $60,000 to have the courts intervene and help me out here. But there were reasons not to. What I did do, and I thought it was pretty clever, while it was going to the appellate division, and that takes time, okay, I went to the man who had owned the property and was being foreclosed, and I bought a deed from him. And I paid a few $1,000s, and I told him the circumstance. He said, oh, cool. You know, he was, you know, a guy who worked around town, just a regular Joe. And he sold me a deed. And the point being that if the appellate division had said, I don't win, but the foreclosure sale has to be remade, I could have then, being the person with the deed to the property from the original owner, I could have made a deal with the bank at that time, or the bank, the mortgage agency holding the mortgage, and had the property. But there was a problem with this property anyway, and this is one of the things, if you're doing these kind of deals, you have to really look at. Originally, the property was two houses. A man had owned a double piece of property, and he subdivided and built two capes. And it was one driveway that veered off to two separate garages, and he sold them off to his children. One lived here, one lived there. So under that circumstance, the common driveway was not a problem. But when they later sold these houses, and other people who didn't know each other owned them, there were fights and arguments over the driveway. This one parks in the driveway to put the groceries in the house, the other one pulls in and can't get in. So it was not a desirable spot under the circumstances. And all in all, I learned some things, and it was a good experience. I got case law on the books, and I'm happy with that. The second case I'm going to talk to you about is I bought a piece of property with power lines overhead, okay? It was Lilco originally when they put the power lines overhead, and then it became Market Span Corporation, which is technically like a conglomerate of comes and goes people. So it's not really an entity in the same sense, but nevertheless, the power lines were overhead. I did a search of the chain of title. The chain of title is this. I bought the property, I own it, I have a deed on record. The person I bought it from bought the property, they owned it and had a deed on record. and going back and back and back. Well, I never found any place where the owner of the property made a easement grant to Lilco. So I said, you know, you don't have anything. And there's an actual statute that says no amount of time in the state of New York where you have power lines overhead can it ripen into the right to use the property. Otherwise, of course, they could just stretch power lines all over the place, and after a period of time they own it, or they have the perpetual right. So there's a statute like that. So I figured, hey, I have this, okay? But I didn't have this. I went to the Suffolk County Supreme Court, made a case to get them off, saying they have no easement grant, and that made the law books, even though it was a lower court. They call the court of original jurisdiction, in this case it was the Suffolk County Supreme Court, they call that the lower court, okay? That made the law books, okay? Now, I did not prevail, which is okay, that's part of doing business, but I figured, you know, let me appeal. So I did appeal, and I went to the appellate division. Now there are 4 appellate departments in the state of New York. We're in the 2nd Judicial Department. So I went to the Supreme Court Appellate Division, 2nd Department, where again I lost, okay? And to me it's bad law, okay? It really spells out the fact that, well, what happened is the first case law that's on the books at the Supreme Court spells out blow by blow all the facts of the matter. This at the appellate division doesn't. It just said it in general terms, you know, you didn't win, which they can do, okay? So I took the first case law that was not on the books, sent it into Westlaw and got it on the books, which you can do sometimes. I did. So all the world is surprised that they created bad law. And that's their problem, because now they have to deal with it in subsequent cases. That situation where a man who had no deed gives him a grant and it's taken as valid. How's the appellate division going to work with that? Well, okay. Now, the third situation I'm going to talk about is where I had taken a quitclaim deed from a woman. These people were evidently in the business of buying properties, many properties, vacant lots, all over Suffolk County. And then they would sell them one at a time, over time period payments and things like that. Well, at the end of their little game, or business, whatever you want to call it, there were vacant lots all around that they still owned. So I went to this woman, and this is in 1992, June of 92, and I got a quitclaim deed of her right title interest of all of her properties lying above and below water in the county of Suffolk, and each of these is to notate it in the records as to which towns. So all 10 towns, okay, I got a deed of her properties in each of the 10 towns, wherever they may be, and that's in June of 92. And then in July of 92, because that deed wasn't really of New York statutory form, I bought it at Staples, and that's not really good enough. I went and I bought a real deed form, and I put on record a correction deed. I had her sign it, and that's what I got. So then I sifted through to find out what I in fact, you know, have for my money. And I found really amounts to a development where this woman had owned the property but never made a deed. Okay, other people had deeds going on that had no original title. Okay, so I sued, and the Supreme Court, Suffolk County Supreme Court, you hear the word Supreme Court, you think big, but it's the original jurisdiction, said my deed's void because it said all of my property wherever situate, and that's not identifying it properly. So there I stood, and there were a lot of properties that I was claiming title to at that point. Well, I appealed, and I was in a spot, okay? Well, anyway, there were a lot of lawyers on the other side, different law firms and different title and insurance companies, and I did in fact prevail. I won. I had the whole thing, and this is the case law on the books. There's a lawyer on it, okay, but I did prevail. Now that set me up pretty good, and then I brought another case on my own. Now this case is October 12th of 1999, where I was a winner. And now here's one in February 23rd of 2000, next year, where I sued on one of the particular properties, basically to get possession of it because I had won on the deeds. The deeds were good. And here the judge, and I really have to give him credit because he did find in my favor in the face of a lot of political opponents, okay? I can't say there was political pressure because I don't know that, I can't prove that, but there were lawyers all over the place, and he did say that I have the property, and that's what this case says, and it's, you know, valid. So I wound up with settlements, title settlements from the insurance companies, the title companies, quite a few of them that do business in the state of New York. And the bottom line is that, yes, I got some money. It's not the kind of money you get out of car accidents when it's being settled. The only real obligation a title insurance company has, unknown to me at the time, but I know now, is to defend the lawsuit and get rid of the plaintiff. And some people told me some of these people wanted to get rid of me. But anyway, they did settle. It was worth it. But they also, the word came down, don't bother coming around looking for title insurance on these deals anymore because you're not going to get it. But I let a little time go by and I went back and I applied for title insurance, and they said, you know, Mr. Zotos, we were very good to you. I caught the drift, okay? And that was the end of that, okay? But I had my game. I enjoyed it. And, you know, the biggest thing I could say is that when you do things in a meticulous way, one step at a time, and you take your time, you can pursue pretty much anything, okay? If you're fair with people, you're honest, you know, even at the end with these lawyers on the other side, you know, there did come a point where it was argumentative between us. And I said to one of the lawyers, I said, you know, you say I'm wrong for bringing these suits, but the fact is, if nobody ever does that, what do they need you for?